102.3, 1240 on the AM. So I'll go to the phone lines real quick.
And we want to welcome Ken Good. He is from the Professional Bondsmen of Texas, and he is going to talk to us about a federal lawsuit involving Harris County, which alleges Texas bail system is unconstitutional. He doesn't agree with this, and he's going to tell us why. Good morning.
Good morning. Thank you for having me.
Well, so explain this case to us, Ken. Tell us briefly what it's all about.
Sure. This is a lawsuit that happened, started probably 5 years ago, where someone was arrested after previously being arrested multiple times and having drug issues in their past. And someone approached them about representing them, saying that the reason why they did not get out of jail on their misdemeanor charges was because they could not afford a bond. Harris County used what we call a bail schedule. And so they alleged that the use of the bail schedule violated due process and equal protection because the defendant did not have an opportunity to ask for a deviation. So, I mean, we keep hearing that they're saying bail is unconstitutional. What they're saying is the procedures that were used in Harris County were procedurally defective, procedurally unconstitutional, not that bail on its face is unconstitutional. But they keep misrepresenting that all over the country, saying that Harris County has held that bail is unconstitutional when the court just said the procedures in place were procedurally defective and required them to be fixed. It's just gone crazy since then.
Well, apparently the bail reform movement seems to be gaining momentum throughout the U.S. What's been going on in Texas in particular?
Well, in Texas, we have, right now, we have two different factions proposing bail reform. We have one side that's pretty much wanting to follow what's been going on in other places. I think 4 years ago, they proposed that we follow the New Jersey model, which has just proven to be catastrophic for their criminal justice system. And even, states like Alaska, which started to go down those roads and found that they were terrible, came back and repealed the reforms. And then we have the governor's office, representing the other side of the spectrum, wanting to make sure that magistrates review criminal histories before setting bail. And so, and more currently, say people accused of killing cops or law enforcement officers should not be eligible for bail at all. So we have both extremes of the argument being made in Texas. And essentially, as a result, at the state level, nothing's happened in the last 4 years.
Well, where do you stand on all this?
Well, I'm an attorney. I'm actually originally from Gorman, Texas, which is really close to Brownwood.
Yes.
I went to Hardin-Simmons in Abilene. I went to Tarleton State. I got my law degree from Texas Tech. So I've kind of been all over Texas. And this seems to be a large county issue. We have schools, we have dropout rates in inner cities rising. We have drug issues rising. We have the failure of families. We have all kinds of issues that need to be addressed. But the problem I see, or the problem our organization sees, is we're trying to address all that in bail reform, and all we do as an industry is we keep people out of jail and we get them to court. Addressing these other issues through bail reform is causing crime to rise, people not to show up for court. It's causing officers to get killed because we have outstanding warrants increase, and so someone gets stopped in a traffic stop and they run warrants and they still have a warrant and the person decides to run. The most recent case involved running over a police officer to do it. So where we stand is that, we can always improve the system. But improving the system is let's keep track of who's in jail. The issues identified by the Fifth Circuit is, if someone has to have procedural protections once they're arrested. So if they have bail set and they haven't posted bail within 72 hours, we've been proposing for probably 6 or 8 years that they be brought back before the judge after 72 hours and asked, why are you still in jail? So, we can always improve the system, but it seems like we are violating an old adage, first do no harm, because most of the proposals that are being made are actually making the system a lot worse because we're trying to address social ills through criminal justice, through bail reform, and that's not a proper place for it, I don't believe.
Well, Ken, what can everyday citizens do to get involved if they are concerned about bail reform?
Well, I mean, we see all kinds. Well, first, you have to take everything you hear with a grain of salt. I mean, I have kids, and I keep telling them that what you hear on the extremes on both sides is probably more rhetoric than accurate, and so you have to listen, and you have to figure out what the truth is, and you have to figure out what's good for our. I mean, this isn't a left side issue or a right side issue. This is a what's best for criminal justice, and so getting what's best for criminal justice is get people to court. And so what's the best way to do that? Well, I mean, our statistics show, especially in Harris County, if you're on a surety bond, you got a 400% better chance of showing up for court. And so who wouldn't? I mean, if I had a child who was having issues, I mean, who wouldn't want them to be on a private bond because they have a better chance of getting to court? And if you miss court, that just creates bigger problems for you. So I think the first thing is we need to funnel everybody that can afford a surety bond to a surety bond, and then we need to set up procedures to identify the true people that cannot, and then we have to figure out, well, do we want to lower their bond? Because the law doesn't require the bond to be lowered because they claim poverty. It says they have to have a hearing and they have to review the fact in 15 of the Code of Criminal Procedure. And then we just have to set up procedures for tracking people and why they're in the county jail before trial. One of the instances we had was in San Antonio, where a lady was in jail and she went to the infirmary. She ended up being there like 6 months or so or more, and then ultimately died in the infirmary. Well, existing law would have required her to be released out of jail because it was a misdemeanor charge after 90 days if she's still in jail. So that was a tragic situation where she should have been released under existing law, and there are people wanting to argue that we should change bail because of her. Well, no, as in many situations, if we would just figure out how to follow the existing law, that would have never arisen.
Well, we want to thank Ken Good for being with us. He's from the Professional Bondsmen of Texas, and thank you so much for shining a light on this issue.
Oh, thank you so much for having me, and Merry Christmas to you.
Merry Christmas.
Bye.